I was sitting in my living room watching the snow pile up outside when I heard the crunch of metal against wood that would change my entire winter. My name is Brian Ellsworth, and I had just bought my dream property 6 months earlier in rural Vermont, about 20 minutes outside of Burlington. The place was everything I had wanted after years of apartment living in Boston. 5 acres of land, a charming 2-story farmhouse built in the 1920s, and most importantly, my own private road leading from the state highway to my property. The road was about a quarter-mile long, winding through a beautiful stretch of pine trees, and it was entirely mine according to the property deed. The snowstorm that February afternoon was a monster. The Weather Service had been warning about it all week, predicting 18 to 24 inches of accumulation. I had spent the morning making sure I had enough firewood, food, and supplies to wait it out comfortably. My truck was parked safely in the garage, and I had settled in with a book and some hot coffee when I heard that sound. I jumped up from my chair and rushed to the window. Through the heavy snowfall, I could barely make out a silver SUV that had clearly lost control and smashed directly into the split-rail fence that marked the boundary of my property, near the end of my private road. The fence, which I had just spent 2 weekends last fall repairing and repainting, was completely destroyed. At least 30 feet of it was either knocked down or splintered beyond repair. I grabbed my coat and boots and headed outside. The wind was whipping the snow around so hard I could barely see 5 feet in front of me. As I approached the vehicle, I could see someone in the driver's seat. The door opened and out stepped a woman in her late 40s, perfectly coiffed blonde hair somehow still in place despite the accident, wearing what looked like expensive winter gear that seemed more suited for a ski resort than actual winter emergencies. "Are you okay?" I called out over the wind. She looked at me with a mixture of anger and indignation that caught me completely off guard. "Your road is a death trap. There is not a single grain of salt anywhere. I could have been killed." I blinked snow out of my eyes, trying to process what she was saying. "This is my private road." "Are you hurt? Do you need me to call for help?" "I am Patricia Morrison, and I am the president of the Maple Ridge Homeowners Association. This is completely unacceptable. Private road or not, you have a responsibility to maintain safe conditions." I had heard about the Maple Ridge development. It was a gated community about 2 miles down the state highway, full of McMansions and apparently people like Patricia Morrison. But I was not part of that HOA. My property predated the development by about 80 years. "Madam, I think you need to calm down. This is my private property, and you were clearly driving too fast for conditions. Let me help you get your vehicle out of my fence." "I will not calm down. Look what your negligence has done to my vehicle." I looked at her SUV. The front bumper was dented and one headlight was broken, but it did not look totaled by any means. My fence, on the other hand, was completely destroyed. "We should exchange insurance information," I said, trying to keep my voice level. "You damaged my property." Patricia's face turned red despite the cold. "I damaged your property. Your failure to maintain this road in safe winter conditions caused this accident. I will be filing a claim against you." Before I could respond, she pulled out her phone and started taking pictures of everything, including the road surface, her vehicle, and the fence. I did the same with my phone, making sure to document the damage to my property and the position of her vehicle. The snow was coming down so hard that I knew we needed to wrap this up quickly. "You need a tow truck?" I asked. "I have already called my husband. He will be here shortly with our other vehicle." She climbed back into her SUV and slammed the door, apparently content to wait in the warmth while I stood there in the blizzard. I trudged back to my house, my mind racing. I had never dealt with anything like this before. Once inside, I immediately called my insurance company and reported the incident. The agent I spoke with took down all the details and assured me that since it was my private road and my property was damaged, I should be covered. She also suggested I file a police report. I called the Vermont State Police non-emergency line and explained the situation. They told me that with the current weather conditions, they could not send anyone out immediately, but I could file a report online or come to the station once the storm passed. I opted to file it online right away while everything was fresh in my mind. About an hour later, I saw a large pickup truck with a plow attached pull up. A man who I assumed was Patricia's husband helped her transfer to his vehicle, and together they managed to get her SUV unstuck from my fence. They drove away without another word to me, leaving my fence in ruins. The storm continued for another day and a half. By the time it was over, we had gotten 22 inches of snow. I spent the following morning plowing my private road with my tractor and clearing around my house. I also documented all the damage to my fence with more photos and measurements. The repair cost was going to be substantial, probably around $3,000 between materials, and the time it would take me to fix it. 2 weeks later, I received a certified letter. It was from Patricia Morrison, but not about insurance. It was a formal notice from the Maple Ridge Homeowners Association claiming that I was in violation of community standards and demanding that I salt and plow my private road within 48 hours or face fines of $500 per day. I read the letter 3 times, certain I was misunderstanding something. I was not part of the Maple Ridge HOA. I had never signed their covenant. My property was not even adjacent to their development. I called the phone number listed on the letter and got Patricia Morrison herself. Mrs. Morrison, this is Brian Ellsworth. I just received your letter and I think there has been a serious mistake. There is no mistake, Mr. Ellsworth. Your failure to maintain that road poses a danger to everyone in this community. But I am not part of your community. I am not a member of your HOA. That is irrelevant. The road you own provides access to the state highway, and members of our community use it regularly. What? No, they do not. It is a private road that only leads to my property. Why would anyone from your development use it? It is a shortcut to the highway. Several of our members have found it much more convenient than using our main entrance. I felt my blood pressure rising. Mrs. Morrison, it is a private road. There are clearly posted no trespassing and private property signs at the entrance. Nobody has permission to use it except me and my guests. Those signs are very small and difficult to see. Regardless, we are giving you 48 hours to comply with our maintenance standards, or we will begin assessing fines. You cannot fine me. I am not a member of your HOA. We will see about that, Mr. Ellsworth. She hung up. I immediately called my insurance agent back and explained this new development. She was as baffled as I was and suggested I contact a real estate attorney. She gave me the name of someone local who had experience with property disputes. The attorney's name was Richard Caldwell, and he had been practicing real estate law in Vermont for 30 years. I met with him the following day at his office in Burlington. After listening to my story and reviewing all my documentation, including my property deed, the HOA letter, and photos from the accident, he leaned back in his chair and shook his head. This is one of the more brazen HOA overreach cases I have seen in a while, he said. You are clearly not a member of their association. Your property predates their development and you never signed their covenant. They have absolutely no authority over you or your property. So what do I do about their threat of fines? Ignore it. They cannot legally fine you. However, I am more concerned about the liability issue. If people from their development are regularly trespassing on your private road, you could potentially face liability if someone gets hurt, even though they are trespassing. How does that make sense? Vermont has some complicated premises liability laws. Even trespassers can sometimes recover damages if they are injured on your property under certain circumstances. I would strongly recommend you install more prominent signage making it absolutely clear that the road is private and that trespassers will be prosecuted. You might also consider installing a gate. A gate would cost a fortune. The road is a quarter-mile long. You only need to gate it at the entrance from the state highway. I can draft a letter to the HOA making it clear that their members are trespassing when they use your road, and that you will take legal action if it continues. Please do that. Over the next week, I installed larger private road and no trespassing signs at the entrance to my road. I also put up a chain across the entrance with a lock, which I could easily unlock when I needed to come and go. It was not a proper gate, but it made it absolutely clear that the road was not public access. 3 days after I installed the chain, I got another certified letter. This time, it was not from the HOA. It was from Patricia Morrison personally. She was suing me for $25,000. According to her complaint, my negligent failure to salt and maintain my private road in safe winter conditions had directly caused her accident, resulting in damage to her vehicle, personal injury, and emotional distress. I sat at my kitchen table staring at the lawsuit papers, feeling like I had fallen into some alternate dimension where nothing made sense. She had driven onto my private property during a blizzard, crashed into my fence, and was now suing me for her own reckless driving. I called Richard Caldwell immediately. He told me not to worry and that he would handle it, but that I should forward the lawsuit to my homeowner's insurance company as well, since they might cover legal defense costs depending on my policy. My insurance company assigned the case to their legal team, but they also informed me that if I was found liable, my rates would likely increase significantly. The whole situation felt like a nightmare. The preliminary hearing was scheduled for 6 weeks later. In the meantime, Richard sent a response to Patricia's lawsuit, arguing that she had no standing to sue since she was trespassing on my private property at the time of the accident, driving recklessly given the weather conditions, and that I had no legal duty to salt or maintain my private road for the benefit of trespassers. I thought that would be the end of it, but Patricia Morrison was apparently just getting started. 2 weeks before our court date, I received yet another letter, this time from the Maple Ridge HOA attorney. They were formally demanding that I grant an easement to their community members for use of my private road, arguing that it had become a customary pathway, and that I was being unreasonable by blocking access. Richard laughed when I showed him this letter. They are grasping at straws. Vermont does not recognize prescriptive easements after such a short period of time, and certainly not when the owner has consistently maintained the private nature of the property. They are trying to intimidate you into giving up your rights. The day of the preliminary hearing arrived. I dressed in my best suit and met Richard at the Chittenden County Superior Court in Burlington. Patricia Morrison showed up with her own attorney, a slick-looking man in an expensive suit named Gordon Phillips. Judge Martha Henderson presided over the hearing. She was a no-nonsense woman in her 60s who had a reputation for being fair but tough. After reviewing the initial filings, she looked at Patricia's attorney with what I can only describe as skepticism. "Mr. Phillips, your client is claiming that Mr. Ellsworth was negligent in his maintenance of his private road during a snowstorm. Is that correct?" "Yes, Your Honor. The defendant failed to salt or plow the road, creating a hazardous condition that directly caused my client's accident. And your client was on this private road because the road provides access to the state highway, Your Honor. Many residents of the Maple Ridge community use it as a convenient route. Is Mr. Ellsworth a member of the Maple Ridge HOA? No, Your Honor, but that is not relevant to the negligence claim. It seems quite relevant to me, counsel. Was your client invited to be on Mr. Ellsworth's property? The road has been used by community members for some time without objection. Richard stood up. Your Honor, if I may. Mr. Ellsworth has had private property and no trespassing signs posted at the entrance to his road since he purchased the property. He has never given permission for anyone from Maple Ridge to use his road. Mrs. Morrison was trespassing at the time of her accident. Judge Henderson nodded. Mr. Phillips, under Vermont law, property owners generally have a reduced duty of care to trespassers. Your client chose to drive on someone else's private property during a blizzard. Why should Mr. Ellsworth be liable for her decision? Your Honor, we believe that the defendant's failure to maintain the road in safe conditions constitutes gross negligence, which would create liability even for trespassers. Gross negligence. The judge looked at Patricia's attorney over her reading glasses. Counselor, not salting your own private driveway during a snowstorm is not gross negligence. It is called living in Vermont. Do you salt your driveway every time it snows? That is different, Your Honor. How so? My driveway does not provide access to a public highway. Neither does Mr. Ellsworth's road. It provides access from the public highway to his private property. The fact that your client chose to trespass on it does not transform it into a public thoroughfare. I felt a wave of relief wash over me. The judge clearly understood the absurdity of Patricia's claim. Your Honor, Patricia's attorney continued, we also have evidence that Mr. Ellsworth acted with malice after the accident by installing chains to block access to the road, demonstrating his awareness that the road was being used by others, and his deliberate intent to cause harm. Richard stood up again. Your Honor, that is absurd. Mr. Ellsworth installed the chain after receiving threatening letters from Mrs. Morrison and the Maple Ridge HOA demanding that he maintain his private property to their standards and threatening him with fines. He has every right to secure his own property against trespassers. Judge Henderson tapped her pen on her desk. I am inclined to agree. Mr. Phillips, unless you have something more substantial to present, I am going to grant summary judgment for the defendant. Your Honor, my client suffered real damages as a result of this accident. Her vehicle was damaged, and she sustained physical injuries including whiplash. Does she have medical documentation of these injuries? She saw her doctor 2 weeks after the accident complaining of neck pain. 2 weeks after? The judge raised her eyebrows. And what does the accident report say about injuries? There was a long pause. There is no police report, Your Honor. The accident occurred during a severe snowstorm and the police could not respond. Did your client seek immediate medical attention? No, Your Honor. She did not feel it was necessary at the time. So she was well enough to drive away from the scene in her husband's vehicle, well enough to not seek medical attention, but 2 weeks later decided she had whiplash. The judge looked at Patricia, who was sitting ramrod straight in her chair with her arms crossed. Mrs. Morrison, did you take any photos at the scene of the accident? Patricia stood up. Yes, Your Honor. I have extensive documentation. And in these photos, can you show me where Mr. Ellsworth's road was negligently maintained? Patricia's attorney passed several printed photos to the judge. I had seen these same photos. They showed heavy snow falling, her damaged vehicle, my destroyed fence, and the unpaved surface of my road covered in snow. Judge Henderson studied them carefully. I see a snowstorm. I see a private unpaved road covered in snow, as one would expect during a blizzard. I see a vehicle that has clearly lost control and crashed into a fence. What I do not see is evidence of negligence on the part of the property owner. Your Honor, the complete absence of any salt or sand on the road surface demonstrates negligence. Mr. Phillips, it was snowing so heavily that any salt or sand would have been covered within minutes. More importantly, property owners in Vermont are not required to salt their private driveways or roads. If they were, half the state would be in violation. She set the photos down. I am granting summary judgment for the defendant. Mrs. Morrison's claim is dismissed with prejudice. Furthermore, Mr. Ellsworth is entitled to file a counterclaim for the damage to his property. Do you wish to file such a claim, Mr. Caldwell? Richard looked at me, and I nodded. Yes, Your Honor. Mr. Ellsworth incurred approximately $3,000 in damages to his fence, which he has since repaired. Mrs. Morrison, you or your insurance company will be responsible for reimbursing Mr. Ellsworth for those damages. I am also awarding him reasonable attorney's fees for having to defend this frivolous lawsuit. Mr. Caldwell, please submit your fee documentation within 30 days. Patricia stood up, her face bright red. This is outrageous. He could have killed me, Mrs. Morrison. You drove onto someone else's private property during a blizzard and crashed into their fence. You are fortunate that Mr. Ellsworth is not pressing charges for trespassing and property damage. I suggest you count your blessings and pay for the fence you destroyed. This hearing is adjourned. I felt like I could finally breathe again. As we left the courtroom, I thanked Richard profusely. He told me this was exactly the outcome he had expected, and that I should receive payment for my fence within 60 days. But Patricia Morrison was not done with me yet. 2 weeks after the hearing, I was working in my garage when a car pulled up my driveway. It was a different vehicle this time, a black sedan, and 2 people got out. Patricia Morrison and another woman about her age with short, dark hair. I walked out to meet them, wary of whatever new scheme Patricia had cooked up. Mr. Ellsworth, Patricia said in a tone that was clearly meant to be friendly but came across as condescending. This is Sharon Myers. She is the vice president of our HOA. We wanted to speak with you about reaching a reasonable compromise. Mrs. Morrison, the judge already ruled on your lawsuit. There is nothing to compromise about. Sharon stepped forward with a smile that did not reach her eyes. Mr. Ellsworth, we understand that you were within your legal rights, but we hope you can see this from our perspective. Several families in our community have been using your road for months. It is simply more convenient than our main entrance, especially during winter when the roads are slippery. We are prepared to offer you compensation. Compensation for what? For granting us an easement to use your road. We would also agree to pay half the cost of maintaining it, including plowing and salting during winter months. I crossed my arms. You want to pay me to use my private road? Exactly. Sharon seemed to think she was making progress. We would pay you $1,000 per year, and in exchange, residents of Maple Ridge would have permission to use the road. It is a win-win situation. And if I refuse, Patricia's friendly facade cracked slightly. Then you would be being unreasonable, Mr. Ellsworth. We are trying to be good neighbors here. Good neighbors do not trespass on private property, crash into fences, and then sue the property owner. I am not interested in your offer. Mr. Ellsworth, Sharon said, her voice taking on a harder edge. I think you should reconsider. The Maple Ridge community is very influential in this area. We have connections with local government, the Planning Commission, the Zoning Board. It would be in your best interest to maintain a positive relationship with us. I felt my temper flare. "Are you threatening me?" "Not at all," Sharon said quickly. "I am simply pointing out that it is beneficial to be on good terms with your neighbors. You are not my neighbors. You live 2 miles away in a gated community. This conversation is over. Please leave my property and do not come back unless you are invited." Patricia's face turned red again. "You are making a big mistake, Mr. Ellsworth. The only mistake I made was not pressing charges for trespassing. Leave now, or I will call the police." They got back in their car and drove away, but not before Patricia rolled down her window and shouted, "You have not heard the last of this." I immediately called Richard Caldwell and told him about the visit. He advised me to document everything and to call the police if they came back. He also warned me that HOAs could be relentless when they did not get their way, and that I should be prepared for more harassment. He was right. Over the next month, I received multiple letters from the Maple Ridge HOA. They claimed that I was creating a public nuisance by blocking access to the road. They claimed that the chain I had installed was a safety hazard. They even claimed that my property was bringing down their property values, though how they figured that made no sense since my property was not even visible from their development. I ignored all the letters as Richard advised. But then things escalated. I came home one day to find that someone had cut my chain. The lock was intact, but the chain itself had been cut clean through with bolt cutters. I immediately called the Vermont State Police and filed a report. They sent a trooper out who took photos and a statement, but without any witnesses or security camera footage, there was not much they could do. I bought a heavier chain and a more expensive lock. 3 days later, it was cut again. This time, I invested in a trail camera and mounted it discreetly in a tree near the entrance to my road. I also installed a more permanent barrier, a heavy metal gate that I had been trying to avoid paying for but now seemed necessary. The gate cost me $4,000 installed, but it was sturdy and lockable, and most importantly, it could not be easily cut. 2 days after the gate was installed, the trail camera captured exactly what I had hoped for. At 2 in the morning, a pickup truck pulled up to my gate. 2 men got out, both wearing clothing with the Maple Ridge logo, which I recognized from their website. They tried to force the gate open, and when that did not work, one of them actually took out a sledgehammer and started hitting the lock. I had been checking the trail camera footage daily, and I saw this video at 6 in the morning. I immediately downloaded it and called both Richard Caldwell and the Vermont State Police. This time, the police took it much more seriously. The video clearly showed 2 men attempting to vandalize and destroy my property. The trooper who came out asked me if I knew who they were. I do not know their names, but they are wearing clothing with the Maple Ridge HOA logo. I am guessing they are either residents or work for the HOA. We will follow up on this. In the meantime, I am documenting this as attempted destruction of property and trespassing. If you can identify these individuals, we can press charges. I sent a copy of the video to Richard, who was livid when he saw it. He immediately drafted a strongly worded letter to the Maple Ridge HOA board, notifying them that their representatives had been caught on video attempting to destroy my property, and that if any further incidents occurred, we would pursue criminal charges and a civil lawsuit. The response we got back was shocking. The HOA claimed they had no knowledge of any such activity, and that if anyone was wearing their logo while committing vandalism, they were doing so without authorization. They actually tried to suggest that I had staged the video to make them look bad. But Richard was not going to let them off that easily. He requested the HOA's membership directory under Vermont's Homeowner Association transparency laws, which required HOAs to provide certain documents to property owners in disputes with them. After some legal back and forth, they were forced to comply. With the directory in hand, I went through the video frame by frame and eventually identified one of the men. His face was partially visible in one shot, and I recognized him from the Maple Ridge website. His name was Kevin Paulson, and he was on the HOA Architectural Review Committee. I provided this information to the Vermont State Police. They contacted Kevin Paulson and brought him in for questioning. I do not know what was said in that interview, but Richard told me later that Kevin apparently tried to claim he was just checking on the gate because they were concerned about emergency access to the state highway. That excuse fell apart when the police pointed out that my private road did not provide emergency access to anything except my private property, and that even if it did, destroying a locked gate at 2 in the morning with a sledgehammer was not the appropriate way to address those concerns. Kevin Paulson was charged with attempted criminal mischief and trespassing. His court date was set for 2 months later. But more importantly, the charges opened up a whole new avenue for me to pursue. Richard filed a civil lawsuit against both Kevin Paulson and the Maple Ridge HOA, alleging a pattern of harassment, trespassing, vandalism, and conspiracy to deprive me of my property rights. We asked for actual damages, punitive damages, and a permanent injunction preventing anyone from Maple Ridge from coming onto my property without explicit permission. The lawsuit got the attention of the local news. A reporter from WCAX, the CBS affiliate in Burlington, reached out to me for an interview. I agreed, and the story aired during their evening newscast. It was framed as "Local Property Owner Fights Back Against HOA Overreach," and it included the video from my trail camera showing the men trying to break my gate. The story went viral locally, and suddenly, I was getting messages of support from people all over Vermont who had their own horror stories about HOAs. Several people told me they had specifically avoided buying homes in HOA-controlled communities because of concerns about exactly this kind of overreach. The news coverage also caught the attention of the Vermont Attorney General's office. A lawyer from their Consumer Protection Division contacted Richard and asked for information about the case. Apparently, the Maple Ridge HOA had been the subject of several complaints over the years regarding aggressive enforcement tactics and questionable fee assessments. As all this was unfolding, Patricia Morrison apparently decided she had not embarrassed herself enough. She posted a long rant on the Maple Ridge community Facebook page about me, calling me a selfish neighbor who was endangering families and making life difficult for everyone just to protect my alleged property rights. The post was shared outside the private group by someone sympathetic to my situation, and it ended up getting back to me. In her rant, Patricia claimed that I had booby-trapped my road with hidden barriers, that I had threatened her with violence, and that I was a danger to the community. None of this was true, of course, but it was all in writing on social media. Richard was delighted when I showed him the post. This is defamation, plain and simple. She just handed us even more ammunition for the lawsuit. We amended our civil suit to include Patricia Morrison personally, adding claims of defamation and intentional infliction of emotional distress. The case was getting bigger and more complicated, but I was determined to see it through. These people had made my life miserable for months, and they needed to face consequences for their actions. The criminal trial for Kevin Paulson came first. It was a straightforward case. The prosecution presented the video evidence from my trail camera, which clearly showed him approaching my gate with another man and attempting to destroy the lock with a sledgehammer. The defense tried to argue that he believed he was acting within his authority as an HOA committee member to address a safety concern, but the judge was not buying it. Kevin was found guilty of criminal mischief and trespassing. He was sentenced to 1-year probation, ordered to pay restitution for the cost of the chain and lock he had damaged in previous incidents, and required to complete 50 hours of community service. He was also ordered to stay away from my property. The conviction was important because it established as a matter of legal fact that representatives of the Maple Ridge HOA had committed crimes against me. That made our civil case much stronger. The civil trial was scheduled for 4 months after Kevin's conviction. In the meantime, the Vermont Attorney General's office had launched an investigation into the Maple Ridge HOA's practices. They were looking into whether the HOA had engaged in systematic harassment of non-members, and whether their fee assessments and enforcement actions against their own members were legal. Discovery in our civil case revealed some shocking information. Internal emails from the HOA board showed that Patricia Morrison had specifically instructed board members to make life difficult for me until I agreed to grant them an easement. One email actually said, "If we make his life miserable enough, he will eventually give in. These types always do." There were also emails discussing the plan to have someone cut my chain, though they were carefully worded to avoid explicit admission of criminal activity. Patricia had written, "The chain keeping everyone out needs to disappear. I am sure someone can handle that." Kevin Paulson had responded, "Consider it done." When Richard showed me these emails, I was stunned. This was not just harassment anymore. This was a coordinated conspiracy to deprive me of my property rights through intimidation and vandalism. We also discovered that Patricia Morrison had a history of similar behavior in her previous community, before Maple Ridge. She had been the HOA president there too, and had been involved in multiple lawsuits with homeowners, including one case where she had filed a lien against someone's property for an alleged HOA fee violation that turned out to be completely fabricated. That case had been settled out of court, but the records showed a pattern of abusive behavior. As the trial date approached, the Maple Ridge HOA's attorney reached out to Richard about settlement. They were offering to pay for all my damages, including the fence, the gate, the chains, and my attorney fees, plus an additional $10,000 in exchange for dropping the lawsuit and signing a non-disclosure agreement. I asked Richard what he thought. He said the settlement offer was reasonable from a purely financial perspective, but that it would not hold anyone accountable for their actions beyond the payment of money. If I wanted to make a statement and potentially prevent this HOA from harassing others in the future, we should proceed to trial. I decided to proceed to trial. This was not just about money for me anymore. It was about principle and accountability. The trial lasted 3 days. Richard presented all of our evidence methodically. The original accident photos, the threatening letters, the video of the gate vandalism, the internal emails, Patricia's defamatory Facebook post, and expert testimony about property rights and premises liability in Vermont. The Maple Ridge HOA's attorney tried to paint me as an unreasonable person who refused to be a good neighbor. They argued that I could have easily granted an easement and avoided all of this conflict. They tried to downplay the vandalism as an isolated incident by a rogue board member acting without authorization, but the emails proved otherwise. The jury saw clearly that this was a coordinated campaign of harassment sanctioned at the highest levels of the HOA. Patricia Morrison took the stand in her own defense. She was combative and defensive, refusing to acknowledge any wrongdoing. She insisted that she had been trying to serve the best interests of her community and that I was being unreasonably difficult. Richard's cross-examination of her was masterful. He walked her through each incident step by step, forcing her to admit that she had been trespassing on my road when she crashed into my fence, that she had no legal authority to demand I maintain my private property to HOA standards, that she had sent threatening letters, and that she had written emails instructing board members to make my life difficult. When he asked her directly whether she thought it was appropriate for an HOA president to organize a campaign to harass someone who was not even a member of the HOA, she actually said, "If that is what it takes to protect my community, then yes." The jury's expressions made it clear that answer had not helped her case. After 3 days of testimony, the jury deliberated for less than 2 hours. They found in my favor on all counts: trespass, vandalism, harassment, conspiracy to deprive property rights, and defamation. They awarded me $35,000 in actual damages and $100,000 in punitive damages. They also granted the permanent injunction preventing anyone from Maple Ridge from entering my property without permission. But the judge went even further. In her ruling from the bench, Judge Henderson said that the behavior of the Maple Ridge HOA board represented a shocking abuse of authority and a blatant disregard for the property rights of others. She ordered that the punitive damages be paid personally by Patricia Morrison, Sharon Myers, and the other board members who had participated in the harassment campaign, rather than from HOA funds, reasoning that the innocent members of the association should not have to pay for the board's misconduct. She also referred the matter to the Vermont Attorney General's office for potential additional action against the HOA. Patricia Morrison's face went white as the judgment was read. $100,000 in punitive damages, split among 5 board members, meant she personally owed $20,000, plus her share of the actual damages and legal fees. For someone who had been so arrogant and sure of her righteousness, the reality of facing serious financial consequences seemed to hit her hard. As we left the courthouse, a reporter from WCAX was waiting. She asked me how I felt about the verdict. "I feel vindicated," I said. This was never about money. It was about holding people accountable when they abuse their authority and try to bully others into giving up their legal rights. HOAs serve a purpose in some communities, but they are not above the law, and they do not have authority over people who are not members. The reporter turned to Patricia Morrison, who was leaving the courthouse with her attorney. "Mrs. Morrison, do you have any comment on the verdict?" Patricia looked directly at the camera and said, "This is a miscarriage of justice. We were only trying to make our community safer." Her attorney quickly pulled her away, but the damage was done. That quote aired on the evening news and made her look even worse. The aftermath of the trial was satisfying. The Vermont Attorney General's office used our case as part of a larger enforcement action against the Maple Ridge HOA. They found that the HOA had engaged in numerous violations of Vermont's Homeowner Association laws, including improper fee assessments, lack of transparency in board meetings, and harassment of members who questioned board decisions. The AG's office forced the HOA to remove their entire board and hold new elections under state supervision. Patricia Morrison and the other board members who had been involved in the harassment campaign were permanently banned from serving in any HOA leadership position in Vermont. Several homeowners from Maple Ridge actually reached out to me after the trial to apologize for their board's behavior. They told me that most of the community had no idea what the board had been doing in their name and were horrified when they learned about it. One couple even told me that they had been threatened with fines for painting their front door the wrong shade of blue and were glad the old board was gone. I received payment of the judgment within 60 days. The insurance company for the Maple Ridge HOA covered the actual damages and legal fees, but Patricia Morrison and the other board members had to pay the punitive damages out of pocket. I heard through the grapevine that Patricia had to take out a second mortgage on her house to cover her portion. Kevin Paulson completed his community service and probation without incident. I never saw him again, which was fine by me. As for my property, I kept the gate and the trail cameras. The gate was actually quite convenient, as it kept out not just trespassers from Maple Ridge, but also the occasional lost driver who might have otherwise torn up my road thinking it was a public throughway. I repaired my fence even nicer than it had been before, using the money from the settlement. I also built a beautiful stone pillar entrance at the start of my driveway with a brass plaque that read, "Ellsworth Property Private Road No Trespassing." It was tasteful but unmistakable. The whole ordeal had lasted nearly a year from the moment Patricia Morrison crashed into my fence to the final resolution of the lawsuit. It had been stressful, expensive in terms of time and energy, and frustrating beyond belief. But standing on my property, looking out over my 5 acres of beautiful Vermont land that was entirely and unquestionably mine, I felt it had been worth it. I learned a lot through the experience. I learned that HOAs could be incredibly aggressive even toward non-members if they thought they could get away with it. I learned the importance of documenting everything when dealing with difficult people. I learned that the legal system, while slow, can work when you have the facts on your side. And I learned that sometimes you have to stand up to bullies, even when it would be easier to give in. About 6 months after the trial, I was working in my yard when I saw a car slow down at the entrance to my road. It stopped, and I tensed up, wondering if someone else from Maple Ridge was going to try something. But then the car drove on, respecting the gate and the signs. That small moment of respect for my property rights felt like a victory in itself. I still live on my property in Vermont. I still plow my own private road when it snows, on my own schedule, using my own equipment. I do not salt it because I do not need to and because it is my private road and I can maintain it however I want. Every winter, when the first big snowstorm hits, I think about that February day when Patricia Morrison crashed into my fence. I think about how a simple accident caused by someone's reckless driving during a blizzard turned into a year-long legal battle because she refused to accept responsibility for her own actions. But mostly, I think about how grateful I am to own a piece of property free from the control of any HOA, and I have no plans to ever change that. The freedom to use my own property as I see fit, within the law, is worth more than any convenience an HOA could offer. I occasionally see news stories about HOA disputes in other parts of the country, and they all have a similar pattern. People drunk on the tiny amount of authority being on an HOA board gives them, trying to control others and refusing to accept boundaries. I hope my story serves as a reminder that property rights matter, and that no one has to tolerate harassment from an HOA they never joined. The last I heard, the new board at Maple Ridge was running things very differently. They actually followed their own bylaws, held transparent meetings, and treated their members with respect. Several of the problem board members from the old regime had actually moved away, including Sharon Myers. Patricia Morrison still lives in Maple Ridge as far as I know, but she keeps a very low profile now. I never saw her again after the trial, and that is perfectly fine with me. My fence stands strong, a testament to quality materials and good craftsmanship. My gate stands strong too, protecting my private road from those who would trespass without permission. And every day, I enjoy the peace and privacy of my 5 acres of Vermont paradise, hard-won through persistence and a willingness to fight for what was right. The whole experience taught me that sometimes the hardest battles are the ones we do not choose, but that are forced upon us by others who think they can push us around. But those battles are often the most important to fight because they are about fundamental principles like property rights, personal freedom, and the rule of law. I never wanted to be in a lawsuit. I never wanted to spend a year dealing with HOA harassment. I just wanted to live peacefully on my own property. But when that peace was threatened, I stood my ground, and in the end, justice prevailed. That February snowstorm seems like a long time ago now, though it has only been about 2 years. The landscape of my property has changed somewhat since then, with the new gate and the improved fence and the stone pillars. But the fundamental character of the place remains the same. It is mine, it is private, and it is free from the overreach of any homeowner association that thinks it can extend its authority beyond its actual jurisdiction. I hope anyone reading this who faces similar HOA overreach will take heart from my story. Document everything, know your rights, do not be afraid to seek legal help when necessary, and never let bullies win just because it seems easier than fighting back. Property rights are fundamental, and they are worth defending. As I sit here writing this on a beautiful Vermont evening, with the sun setting over my property and my fence standing proud and intact, I know I made the right choice to fight back. Some things are worth the battle, and keeping my freedom and my property rights was definitely one of them.